Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today may be the day I earn your subscription. For today's live stream, we are doing an update on a case that is a year and a half old and hasn't had anything happen in it for quite a while. This is the case of Amanda Cohoon, in which case Amyiah, apologize, not Amanda, Amyiah. In which case Amyiah is a high schooler. And in March 2020, her high school class went to Disney World. And she started feeling sick shortly thereafter. We'll get into the whole background because the court's going to summarize the case, and I don't want to say it twice. But she posted on Instagram, a sheriff demanded that she take down the post, and because it was causing a panic, and so forth and so on. So previously we have covered the complaint, we have covered the response, we did a review of the video, and we saw some areas that were possible. And now we're going to do an update from the new judge. So one of the reasons that this has been going on for a while is there was a transfer of cases. And so the new judge is trying to catch up on all their old stuff. Plus, the civil system in generally has been overly burdened as a result to COVID or during COVID. Maybe not as a result of, but during the same time period. So, yeah, this is an update on a case that's a year and a half old where we've just been waiting around for something to happen. So something happened. There was a status conference today, in which case the attorneys appeared, and there was some discussion, and there was some comments made from the judge that will readily forecast, I think, where we're likely to go. So let's just get started. So I can't record it or broadcast it, but I can take notes. And I took copious notes. So this will be pretty close, but not obviously word perfect because I don't have a transcript. So here's what was discussed in the case. The court began with a recitation of the case's history. What was filed when, what documents were filed in what time period, this was filed this date, this date, this date. And then after a brief recitation of the procedural history, the court asked if the parties had any comments as they proceeded. A defense counsel, which is representing the sheriff and some other people, indicated that there had been some attempt at a settlement in the past, but obviously no settlement had been reached. The defense counsel also indicated that there had been no arrests or charges as a result from the facts of this case. So Amyiah was not in fact arrested, nor were her parents. There were no arrests, there were no charges criminally as a result from the case. The court then inquired about whether or not it would be fruitful to have further settlement talks, pointing out that they have magistrate judges, including some magistrate judges who do nothing but settlement talks. So if you've had some settlement, would you like to try again? And both parties pretty much nixed that right immediately. They're both parties are like, no, we're just ready for a ruling now. We're just ready for a ruling. Both sides are like, we're ready. We're ready to go. So then the court indicated that they had watched the dash cam video, which we also watched together on our stream and we responded to. The court made a point of saying that they thought that the dash cam video and audio was particularly good quality, and made a point of saying that normally in a lot of these situations, you don't get really good video or really good audio. This is true. There's a lot of other things that are going on in a lot of situations, but this particular situation, we had very good video and very good audio. So we had a pretty good recitation of what was occurring factually. So then the court began with a recitation of the facts. So this is how the court understands the facts. And also said that it believes that these essential facts are undisputed. In March of 2020, the school district went on a trip to Florida, specifically Disney World. About a week afterwards, the plaintiff began to feel ill. Sometime after March 22nd of 2000, the plaintiff went to a hospital, this is Amyiah, and there were noted symptoms consistent with COVID, but there was no COVID test done at that time because at that time, COVID tests were hard to come by. This is in the very early stages of the pandemic. This is March 2020. Okay, so the tests that are available are very limited, and also, I'm not sure particularly accurate, but they'll get into that. So there was no COVID test done at the time, although the doctors noted symptoms consistent with COVID. Sometime after March the 22nd, the plaintiff notified her band teacher because it was a banned trip to go to Disney World. And also posted on Instagram a post saying that she had had COVID-19. She then self-quarantined until she got worse. She went back to the hospital and posted from the hospital. The court then notes at this time there was significant uncertainty about COVID and the nature of the threat. This is March 2020, right? We don't know what this thing is at all yet. So, as a result of these diagnostics that were being made, the public health department contacted the hospital, presumably, and I don't remember exactly why, but I think the hospital contacted the public health department about a potential, potential pathogen. So the public health department contacted the hospital, and the hospital indicated that the plaintiff needed to be transferred because of the nature of their symptoms. She was, in fact, transferred to a child's hospital, and at this time, she was tested, but the test returned a negative result for COVID. So the only test that she received was negative. The plaintiff then made a post regarding that she had beaten COVID. So she makes these Instagram posts, which is the thumbnail for this video, right? I'm taking a picture of me in the mask. I've beaten COVID, all the rest of it. So at this point, the school principal becomes aware of all this. This is the way the court recites it, at least. At the time, there were no confirmed cases of COVID in the entire county per health authorities. Again, this is March 2020. It's the very early days of COVID. So there are not a lot of tests going on because testing is still kind of in its infancy. So the health authority says there are no confirmed cases of COVID at this time. The school starts getting significant calls concerning COVID because a lot of the people, it's on Instagram, it's public. So a lot of people are saying, do I need to quarantine? Am I sick or not? So the school is starting to get inundated with calls. At some point, the sheriff becomes aware of all this and visits the house, which is the dash cam video we saw. After a 30-minute conversation, the plaintiff took down the post relating to COVID. The sheriff threatened to issue citations and to take people to jail if the posts were not taken down. We saw that. I'm going to cite you. I'm going to arrest you. Public disorder. We saw all of that. So then with that recitation, the court then inquired if it had a correct understanding of the facts. The plaintiff's counsel added that the plaintiff's counsel added that the doctors had told plaintiff that she might still have COVID despite the negative test, and that where the court had said it was a request to take it down, the plaintiff made a point of saying, no, it was a demand. It wasn't a request. So everything you said is true, except she was also told that she might have COVID. Then there's notes in the medical records to indicate this, like the symptoms consistent with COVID. And also it wasn't a request so much as a demand. So that's what plaintiff's counsel said. Defendant's counsel emphasized the nature of the testing at the time and that it was somewhat unreliable, and also that all the words that actually explicitly indicated a threat, such as I will arrest you, I will take you to jail, etc. and so forth, none of those words were actually uttered in front of the plaintiff, Amyiah. That's true. All those words, Amyiah was not there at the time. She was inside the house, so she may or may not have overheard, but there's no allegation to that, at least on the record. And she was not physically present at the time. She was inside the house when these threats were indicated, so fair enough. So now the court gets involved in its analysis. So the defendant's basically is trying to say, the defense counsel is trying to say, this wasn't really a demand. It was a request. There was all that stuff. So the court then says, if a sheriff deputy shows up at a girl's house and asks a post be taken down, that's coercive. That's what the court said. It said it's coercive. If you show up in full uniform with a gun and, in a sheriff's car and you ask, that's really not an ask. It's an order. It's coercive. The court goes on to know, in conversations with the plaintiff's father, his statements that he made to the father regarding taking people to jail indicates his intent. And even if the post had already been taken down at that time, because there was an issue of the timeline, right? Maybe the post had already been taken down at the time the threats were uttered. So even if that was true, the court then said the statement of intent informed the entire conversation, which I thought was really, really nice, because the court basically is trying to say at this point, from the court's point of view, the timeline doesn't matter. Because the defense was trying to say, which is a perfectly reasonable argument for the defense, trying to say, initially it was a request. Okay. And any sort of threats of, I will arrest you, I will ticket you, I will take people to jail, didn't happen until after the posts had been taken down. So trying to argue, basically in the timeline, the threats are irrelevant because they couldn't have influenced the decision to take it down because they happened afterwards, right? So it can't be part of the analysis. And the court actually kind of goes the other way and says, actually, the timeline itself is irrelevant because those overt statements help inform the sheriff's intent throughout the entire conversation. So the court makes the point, and quite reasonably, that what the intent of the officer is, or what they're trying to communicate, might be ambiguous. But these overt statements, even though they occurred at the very, very end, they inform all the intent. So it informs and might be a reflection of their entire demeanor and intention. So even though it occurs last in time, we get to bring it all back and say, no, actually, this was the subtext the entire time. And subtext became text, but it was still the subtext. The court is not having it. The court then indicated, because there was a the plaintiff made a request for a restraining order. So the plaintiff wanted an injunction, restraining order, that would prohibit the sheriff from arresting people related to these posts. So the court then says, essentially, I'm not sure I can do that because you're asking me to make a restraining order for the sheriff doing things based on things the plaintiff hasn't even done yet. Because this is forward-looking. The idea is that the threat to arrest is a threat for future conduct. But we don't know what the nature of the future conduct is because it hasn't occurred. There hasn't been any Instagram posts, I think maybe at all, and certainly related to this since it occurred. The court then notes injunctions need to be specific, and the court does not know what will occur in the future, and the court is concerned about how any such injunction could theoretically be crafted. The court also makes a point of saying that it's at least theoretically possible that Amyiah could make overt threats, true threats. And those have to be actionable by the police. So the court is concerned, how can it write an injunction that will bar the kind of conduct we're interested in without prohibiting the police from actually enforcing laws should they be broken in the future? The plaintiff's lawyer, speaking for Amyiah, indicates that the injunction request that they made was attempted to be narrowly drafted to avoid the problem. So the way the plaintiff counsel says, basically, I hear you, you're right. I tried to draft the request in such a way to avoid this issue because I basically said anything arising out of her diagnosis of COVID-19, I tried to constrain it in some way so that it wouldn't run into this problem. So I'm aware of the problem. I've at least attempted to address the problem. Good response. And then there was a discussion about the nature of the declaratory relief. So in addition to the injunction, restraining order, there's also a request for declaratory relief. Declare my rights were violated. And defense counsel made a statement, plaintiff's counsel made a statement saying that declaratory relief would be sufficient, which of course the court is going to leap over in a split second. So they say, well, merely declaring that my rights were violated would be enough. I don't need the injunction going forward. So the court's going to absolutely take advantage of that and do that all day long. So the odds of an injunction being granted are very low because the plaintiff just said, if you give me a declaratory relief, if you say my rights were violated, I'm good. So the injunction is very unlikely as a result. Where was I? So then there was an inquiry from the court as to case law regarding retaliatory speech So there was a citation to a U.S. Supreme Court case. I didn't make a note of the case in my notes, but so there's a case on this point and said, here's the law from the Supreme Court dealing with what retaliatory speech looks like. It's a 3-factor test. I didn't manage to get down, but basically that it derives from the First Amendment conduct, and that so the plaintiff says, okay, all these factors are satisfied, so we think we can meet the Supreme Court's test. The court indicates that in the prior case, so the court did a little discussion of the prior case from the Supreme Court, that if the police had probable cause to arrest for a valid crime, it would preclude retaliatory speech claims under the First Amendment. So the district court reads the Supreme Court as saying, and it's correct, that if there's valid cause to arrest, you can't claim that there's an arrest for retaliatory speech. This is just also generally true in law more broadly. If the police have valid reasons to arrest and invalid reasons to arrest, the valid reasons to arrest control. This is one of the reasons that there's the pretextual stop, right? We're stopping you. The pretext we're stopping you for is because you sped, or you forgot to use your blinker enough distance, or you crossed the line, or, insert any one of 5 billion other traffic violations. That's the surface level reason. The real reason we're stopping you over is because we are suspicious of stuff which we don't have any reason to pull you over for, but we're going to because you failed to use a blinker, and that's a violation. And the Supreme Court has said quite clearly in the past that, yeah, as long as they have a valid reason to pull you over, which doesn't need to be an arrest, it can be a Terry stop. So as long as they have a valid reason to pull you over, do the investigatory stop, or a valid reason to arrest, whatever invalid reasons they have are irrelevant. They just need to have valid reasons. So fair enough. So if they had a valid cause, you can't sue for the retaliatory speech. All right. So plaintiff then comes back and says, well, there's no probable cause for disorderly conduct. That was the statement from the sheriff. I'm going to arrest you from disorderly conduct. There's no probable cause for that. The speech at issue does not comprise disorderly conduct. Even if it actually caused fear in the relevant community, mere fear is insufficient. You need more for disorderly conduct than mere fear. It's like you don't have probable cause for disorderly conduct. All right. So then the court asked about state-specific law. So they talked about this case in Ray Douglas from the Wisconsin Supreme Court and how in that case there was probable cause to arrest. So defense then, picking up on that, the defense counsel says probable cause or arguable probable cause under state law, and also the county-specific municipal code. So not only is there state law, the county also has its own disorderly conduct code. And in this particular code, it makes it a criminal offense, or at least a citable offense, to use a computer to send a message for the purposes of annoying another. And I don't know if that's legally precise language, but, same idea. Defendant argues that the situation must be judged based on what the officer knew at the time. So at the time, March 2020, there's a lot of fear and uncertainty. It was causing a lot of actual disruption that caused the health department and sheriff to be involved. So, again, early days of COVID, at the time, there are no confirmed cases of COVID in the county. Someone has just said, I have COVID. The school district is getting lots of calls. The health department is involved. The school principal is well involved at this point. And now the sheriff is involved. So there's a lot of uncertainty and doubt. So basically saying we should judge this situation based on what the officer knew at the time. And the court just destroys them, which was hilarious. The court just comes back with saying, well, maybe people should have been concerned at the time. So this entire argument from the defendant or the defense counsel is like, geez, there was a lot of fear and uncertainty about this new novel disease. People didn't know what it was. There was a lot of panic and concern. And the court just basically says, yeah, and so what? Basically, in so many words, people should have been concerned. People should have been panicked. This is a dangerous disease. I don't know if the court actually used that word, but it's like, fear when there's actually something to be afraid about is okay. And this is me speaking, not the court. It's the classic fire in a crowded theater. When there's actually a fire in the theater, it's okay to yell fire. It's okay to yell fire when there's in fact a fire. So maybe it's not so much inducing a mass panic as, people should really be worried about this. So the court just takes everything the defense said about, there's all this uncertainty and doubt, and the band teacher's getting calls, and the principal's getting calls, the health department's getting calls. So many calls, and people are talking amongst themselves. There's so much fear. And the court just says, yeah, and so what? And you could just feel the defense case getting deflated right before your eyes. It was a moment to behold. It's just like, and yeah, so what? It was great. So then the court then says also, if you read the ordinances as broadly as they're written, which says, I think, something like using a computer to send a message to annoy another, which it might literally be saying that in part. If you read it that broadly, there's significant problems with freedom of speech. So if you read this disorderly conduct statute as broadly as it's written, you're running into First Amendment problems rapidly. Okay. So defendant tries to save this situation by indicating the problem wasn't that there was a generalized concern over COVID. It wasn't that Amyiah was saying, I've heard about this thing called COVID and maybe we should be concerned about it. It might spread into our community. No. The problem was that there were people on this trip to Florida, including immunocompromised people. They were informed that they were in contact with a person who had actually tested positive for COVID. I'm not sure who informed them of that, incidentally. But that was so there's a bunch of people on this trip that think that they've been in contact with someone who has COVID. So it isn't just that COVID is bad. It's more specifically, you've been in contact with someone who has this disease. The court also inquires about the false negatives, whether or not there are false negatives in testing. The defense counsel indicated that false negatives are very rare. I'm not sure what basis they're using that on, but that's what they said. And the plaintiff had claimed that one of the reasons that they had tested negative was because they missed the testing window. So I definitely remember this being a thing in the early days of COVID. Like if you didn't test within particular time periods, if you tested too late, it would return negative, even if you did have COVID. So then the defense counsel makes this claim that the idea of testing windows has been debunked, which, if that's true, is news to me, and definitely not in the court record. But apparently this idea of testing windows is debunked. So false negatives are really rare, and testing windows are not a thing. So if she had COVID, she should have tested positive. I'm not so sure about all that, but okay. Defense then says, based on what's known at the time, they say there's arguable probable cause given facts known at the time because of all the fear, uncertainty, and doubt. It's like we just need arguable probable cause. We got it. What the officer knew at the time was the plaintiff had tested negative. This appears to be correct because this is an exception to HIPAA. HIPAA doesn't cover all the things. And one of the things it doesn't cover is particularly contagious diseases, which COVID definitely qualifies. So there's no HIPAA issue here before anyone gets involved in that. So the health department is talking to the school and talking to everyone, and HIPAA is probably not a problem. In any case, what the officer knows is that there was a negative test. This person has not tested positive for COVID, and that's true, at least from testing. So that's what they say. Then the court comes back saying basically they're having no part of it, that argument would swallow the rule. And that the argument is, and they use the words, totally incompatible with the First Amendment. The court's not really feeling it right over here right about now. If you go down that road, your argument swallows the rule. The rule in this case would be the First Amendment, by the way. So your arguable probable cause of, there's a lot of fear, uncertainty, and doubt, and the officer knew there had been a negative test. It's like, yeah, but your argument is completely swallowing the First Amendment. So I'm not having any part of that. Totally incompatible, to use exactly the court's words. That was nice. Defense lawyer comes back arguing that this situation is not analogous to a sheriff who merely dislikes a post for political perspectives, like, vote for this person or vote for that person or whatever. So it's not that. This situation's different. There were 100 people on the trip, and the situation was in fact causing panic in the community in reality. The court then comes back with, people should be panicking. People should be worried. Maybe if people had been worried about COVID in March 2020, maybe we wouldn't be where we are. So the defense like, well, people were panicking. And the court's like, maybe they should have panicked more. It's like, where do you even go from that? Where do you even go from that? People were panicking. People were uncertain. People had so much fear. Yeah, maybe not enough of it. Maybe more of that. I don't know where you come back from that. That's hilarious. The court feels that public health authorities were trying to purposely put a lid on it because they're trying to stop fear. Not because it wasn't true, just trying to stop fear. So they're trying to put a lid on it. The law doesn't allow the sheriff to silence speech. And quote, this is not how our country is supposed to work, unquote. The district court's not feeling it. I'd also like to make a note here that the plaintiff's lawyer has said F all for quite a while now because they don't have to. Just let your opponent make mistake after mistake. Don't interrupt them when they're making a mistake. So plaintiff's counsel over here has not said anything for quite a while at this point, probably because they're enjoying the show. They're not going to say anything for a little while more. The defendant then comes back by saying there's no evidence the plaintiff was diagnosed with COVID. And the court actually pulls an uncivil and just says, what? It was great. It was great. Defendant says there's no evidence they've been diagnosed with COVID. Court says, what? And I wrote in my notes, lol. Defendant attempted to argue that the requirement to quarantine was not a diagnosis of COVID because she was told to quarantine, but that's not the same thing as being diagnosed. Okay. Court indicates that it felt rather troubling in all this, that rather than like the school principal calling the family, or the band teacher calling the family, or the health authority calling the family, or the doctors calling the family, rather than any of those people, the court found particularly troubling that it was a law enforcement officer in the vein of a sheriff. And the court calls it, quote, an odd and coercive approach, unquote. So the court then indicates it will put it back into its pile and it will try to get out a decision within 30 to 60 days. The court then asked if there was anything more. The plaintiff making exactly the same point I would make, the plaintiff finally speaking for the first time in a while at this point, emphasizes that even though there was a negative test, the doctors had informed the plaintiff that she had COVID. Right? Just want to make that 100% clear. Like, there might have been a negative test, but the doctor said COVID. So that's a diagnosis. Like, the test says one thing, the doctors disagree with the test. So that, yeah. And then the court finished with this strange line, which I had to think about for a while. The court indicated that they weren't sure that it mattered because they weren't sure if the veracity of what the plaintiff said was material. And I had to think about that for a second. It's like, okay, so the court's saying, we're not sure it matters what the doctor told the plaintiff or if the plaintiff is even trustworthy. Right? We're not sure if it's material. Now, why wouldn't it be material if the plaintiff is trustworthy? Because it would be irrelevant. Right? So the court is saying that whether or not Amyiah is telling the truth or whether or not she is to be believed is actually irrelevant to the analysis. And I think about that for a second. I'm like, okay, so this court is basically going whole hog First Amendment. Right? The First Amendment does allow you to say false things. Not about people, because that's defamation. But you can say untrue things in the First Amendment. So the court then, after this line, ended the conference, so it didn't have time to expound, but I'm like, well, the only reason it doesn't matter is because it doesn't matter whether or not she believes she had COVID or not. It doesn't matter whether or not she was told she had COVID or not, because even no matter what, she had the First Amendment right to say it. So the court says it's going to issue its decision in 30 to 60 days. So given everything I just said, how do you think this decision in 30 to 60 days is likely to read? What do you think the decision from the district court is likely to be within 30 to 60 days? Well, I think the odds of declaratory relief are looking real good right about now. Real good. So if you're Amyiah and their attorney, you're on cloud 9 right about now, because you're like, yeah, we're going to win. Now, I didn't necessarily think that was a certainty, because I thought that the defense, and this is just me being honest, right? I give you honest legal analysis over here because it's part of my job as a good legal educator. I thought defense's counsel's argument made perfect logical sense. They made the right arguments. Their arguments are completely correct legally. There's a whole lot of uncertainty. We go with what the sheriff knows at the time. They know there's a negative test. We're concerned about these rumors being thrown around and stilling up fear and uncertainty and doubt. And we know there's no COVID, so it must be for attention, and it's causing actual panic. The defense lawyer's arguments are completely correct. It's just the court is like, no, go away. And I don't think that's necessarily a given, because we've covered enough qualified immunity decisions on this channel to know that, yeah. So, and it was interesting too, because in this entire discussion from the court, the words qualified immunity never came up once, which is odd. So, because if you're thinking about this from a strict legal perspective, so now I have to decide whether or not I think the court is right. From a legal perspective, is the court right? So the court seems hell-bent on granting a declaratory. Here's what the court's likely to do, and then I'll do my analysis. The court's likely to give the declaratory relief. That seems pretty clear, right? They're likely to say, yes, your rights were violated. They're unlikely to give injunctive relief, both because it's hard to craft from a technical perspective, and also because the plaintiff said, we're good with the declaratory relief, so why bother? So yeah, what you're looking for from this decision is a declaratory relief, your rights were violated. And then maybe there'd be some assessment as to potential damages, which the court also didn't get into. So that seemed to be where the district court's going. So then the next logical question is, how about qualified immunity? So let's look at this from a qualified immunity perspective, which I know is everyone's favorite topic, but I'm going to give you my legal analysis, even though I just wish to state up front on a personal level, because I know I'm about to get criticized to death. I believe in the First Amendment. I value the First Amendment. I believe it's a thing. Unfortunately, qualified immunity is also a thing. I'd be a bad legal educator if I didn't have to contend with the fact qualified immunity is a thing. I believe in I don't think qualified immunity should be a thing. I'm just telling you it is a thing. This isn't always about what I want. Justice Scalia once said, and I think it's very true, a judge who always reaches the decision they want to reach is probably a bad judge. This is probably going to be one of those times. Please don't hate me. It's just the law. What do you want from me? I'm just here to tell you what the law is in my opinion. So if we're looking at this from a qualified immunity perspective, I think the sheriff has to win. And I hate the fact that that's true. I really do. I think I hate that it's true, but it's got to be correct. In order for you to beat qualified immunity, you have to show that you had a right that was violated. So we got step 1 and was clearly established at the time. And I think you're going to have a problem in step 2, particularly given the factual posture of reality at the time, because the factual situation of this is novel, particularly in March 2020. It's a novel virus. It's very novel in March 2020. Everyone's completely panicking. Panicking is bad. truth is good, unclear fear is bad, and whatever the health department's motivations might have been, whatever the principal's motivations are, we're only suing the sheriff. So we're looking at this from the sheriff's point of view. The sheriff has a statute which says, you can't use a computer device to annoy others. And we're beyond just mere annoyance. We're causing actual distinguishable panic and fear in the community. It's palpable. And so I think the qualified immunity analysis goes the other way. So there was no discussion of qualified immunity in this whatsoever. The sheriff is clearly acting in their official capacity. I mean, they're being called out on duty in a car, in a uniform. It's in their official capacity. So, yeah. So if we're trying to sue under 1983, that's not going to work. If we're trying to sue under some state-specific law, maybe, but it's been a while. So I think the district court is going to say declaratory relief, and I think the district court is wrong. That makes me sad. That makes me sad inside. And wouldn't be the first time a district court would get reversed on appeal on a qualified immunity decision. We see that happen all the time. All the time. We do a lot of these cases on my channel. It's true. So, this is definitely not one of those rare cases that and there's nothing, So I think the district court is about to be wrong. I hate my life a little, but that's where we are. So I give you a summary of what the court talked about. I give you a summary of where the court's going, and then I give you a summary of the legal analysis, and I black pill you all, and I tell you it's not I'm sorry. So, yeah. Yeah. So the sheriff isn't interpreting tests. The sheriff is just being told there's a negative test. Yeah, the sheriff was told there's a negative test by the health department. He's not interpreting it. He's just flat out told it. So let's do some questions now that you all secretly hate me or something. And if the court comes up with a qualified immunity analysis that makes sense, I'd love to read it. I'll tell you that. But there's a qualified immunity problem here that's currently being, Let's look at my bot for questions. So Joe's Med asks, were you actually listening to it live? Yes, I was actually listening to it live and taking contemporaneous notes. Michael said, you were an observer? Yes, I was an observer. I was just listening. It's a public hearing. I called in like anyone else. I think I was the only observer there, but whatever. Yeah, Joe's Med said, what was the Napoleon quote? Don't interrupt your enemy when he's making a mistake. Exactly. Did the plaintiff ask for money or just injunctions, declaratory relief? I don't remember. I'd have to go check. Why would qualified immunity come up? Because it's in professional capacity. Why didn't they bring up qualified immunity? They did in the papers. It just wasn't brought up in the status conference. It just wasn't brought up in the status conference for whatever reason. The defense lawyer was getting destroyed. Azra said, Uncivil. Rights don't exist. The government says so. They're inconvenient to a convenient tragedy when a power grab is won. I feel you, Azarath. I feel you. Azeroth says, we need every country and the lawyer in the country to stand up to the bar and denounce qualified immunity. Yeah, what was wrong with the old test? Let's make Skidmore great again. Skidmore was fine. 1983 against the department still works. If you can show, in order to get 1983 against the department, you have to show some sort of policy or practice from the department that led to the violation. And I don't see anyone that's obvious. So I don't see how you get to the department under Mundell. Because there's no policy or practice here. Yeah, I don't see it. So, no. So the department's not responsible either. I don't see that working. Since 1A was in effect at the time, why does qualified immunity attach? Because the Supreme Court said it does. It said it, I don't know, quite a few years ago at this point. 40 years ago or something. Yeah, because I don't know what to tell you. Oh, also because the Supreme Court said that when you're determining clearly established, you can't determine it at too high a level of generality. That would be the other reason. When you're determining whether or not something has been clearly established, you can't determine it at too high of a level of generality. So the First Amendment exists is what I would determine is too high a level of generality. It's not going great. Maybe it shocks the conscience, so it gets over QI2. Yeah. Did the father inform them, the sheriff, that the doctor told him it was COVID? I forget. The entire dash cam video is available. We did a whole analysis of it, but yeah. I thought the Supreme Court was loath to create law out of whole cloth. Well, they did. They did. We used to have a much better standard. It wasn't the best standard ever, but it was better. You know, we used to have this thing called Skidmore. That's why I say let's make Skidmore great again. Skidmore was fine. Maybe it could be revised, but still better than what we had. Under Skidmore, we'd be asking about the reasonably prudent officer, which is just the reasonable man test. And the reasonable man test is older than dirt. So it was fine. It was functionable. You know, we should be talking about the reasonable man test. Incidentally, under Skidmore, I'm not sure this comes out any differently, which is depressing, but it's still a better standard overall. So we'd be asking about the reasonably prudent officer. Yeah, even under Skidmore, he probably wins. That's really sad. What's the case name pre-QI? Skidmore. Skidmore versus who? I don't remember the other name. As you may or may not know, most lawyers refer to cases just by one name, but hold on. Versus Swift. Yeah. Skidmore versus Swift. 323 U.S. 134, 1944. Have fun. Also, unlike crowd theory, what's the harm from panic in this case? I mean, panic is always a problem. Obviously, the threat from panic in a crowd theory is the fear of being trampled. But to borrow a line from Men in Black, a person is rational. People are dumb, finicky animals, and you know it. And it's like, yeah, panics are always a problem because panics induce all kinds of really strange behavior, not necessarily for the best. Yeah. Now that I've Pacer, I want to go into debt. Well, one of the nice things is you can use Court Listener. Court Listener has many cases for free. There's an extension called Recap, which is Pacer backwards, which is also kind of cute. So download the Recap extension on your browser, and if the case is on Court Listener, you can just see it for free because someone has already uploaded it. And the nice thing is the extension sits in the background, and I have it on my browser. So anytime I look up something that I have to look up and pay for Pacer, no one ever has to pay for it again. Because I looked it up and I put it on Pacer. So I paid the $1.90 for you. So yeah, Recap is your way to solve that problem. Yeah. So I think the district court is going to say declaratory judgment. I think the district court's wrong. I hate my life. I hate my life. But that's where we are. But maybe the district court will come out with some sort of genius qualified immunity analysis that will save us all. We'll see. I wonder if actually Is qualified immunity available in a strict declaratory relief situation? Maybe the qualified immunity isn't. Hold on. Maybe qualified immunity isn't a thing because we're not asking for money. Now I have to go look it up. What exactly relief are we looking for here? And then I have to find out, does qualified immunity exist in a purely declaratory context, which I don't know the answer to, actually, now that I think about it. So maybe qualified immunity isn't a thing. Let's find out. Let's do some legal research together, live. Ooh, is qualified immunity a thing if all you're trying to do is declaratory relief? I don't know. Now, if Court Listener would load, it would make it a lot easier for me to look up stuff. So Court Listener, anytime you want to load, it'd just be great so I don't have to keep stalling. Anytime. Anytime at all, Court Listener. This is one of the problems of doing it live. We're going to do it live. No, we're not, because Court Listener doesn't want to play nice. Come on. Load. All right, so while Court Listener is loading, let me load Westlaw real quick. Westlaw, thank you. Let me load Westlaw real quick, and let me do a quick search for qualified immunity and declaratory relief and see what pops up. We're going to learn some law together. How exciting is that? Can you use qualified immunity in a purely declaratory relief situation? Let's see. Blah, blah, blah. Blah, blah, blah. Court Listener finally showed up. Thank you, Court Listener. Let's take a look at this case. Let's take a case at the claims of relief. What were we asking for? Let's take a look at the complaint. Nominal damages, which might be enough. So we asked for declarative injunction and nominal damages. The nominal damages is probably enough. The nominal damages is probably enough. To avoid the question. I guess the court could always say no. Nominal damages, by the way, is $1. It also triggers attorney's fees provisions, because if you're successful in a civil rights suit under 1983, under 1988, you can get attorney's fees. So if you get the $1, then you get attorney's fees. So, but I don't know if you actually had a true declaratory relief, if you could, and I can't find anything on Westlaw in my 5 seconds of searching, so I don't know. But the fact that you're asking for the $1 might be enough. Might be enough. Yeah. Okay. Well, that brings us to the end of the stream. I hope you enjoyed this update for whatever value it has. So, Amyiah, I think you're going to win at trial. And Sheriff, I think you're going to win on appeal. Also, you suck. But that's not a legal analysis. And, as always, we try to give good legal opinions no matter what I think personally. Because that seems like a good thing to do. But maybe the district court will come up with some sort of genius analysis, either avoiding the issue completely because somehow it doesn't apply in this context. That'd be great. Or coming out with Are we back? Okay, we're back. So we'll do the outro now that we're back. If you've enjoyed this stream, please remember to give it a like. If you're not subscribed already, please remember to subscribe. Did you know for 99 cents you too can become an uncivilian? It's true. You get the cool little icon by the next of your name, like Noli has, or Joe's Med has, or Eva has. You get the cool little thing, and that's all good. And we'll do all that. Qualified immunity is not available against individuals when injunctive relief is sought instead of or in addition to damages. Really? Hold on. Let's speed read a U.S. Supreme Court case and see if it solves the problem. Let's speed read a U.S. Supreme Court case and see if it gives us the answers. 242, let's take a look. I don't want the syllabus, I want the actual decision. I want the decision with page numbers, please. Oh my God. Hold on, what was that citation? I'll just look it up in Westlaw. Now I have to wait for Westlaw to load. Google Scholar? Okay, there we go. $242. Scroll. I'm not seeing it. Hold on. We can do it live. We can do a legal analysis live. Blah, 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 blah. Two-step rule. Is immunity rather than defense. Objective reasonableness principles. Blah, blah, blah. Defense from liability, asserted pleading stages. Qualified immunity, presumably. Entry did not violate clearly established law. I don't see it. 242? 242? Hold on, let me just read the entire page. Okay. Okay. And then it cites a different case, noting that qualified immunity is unavailable in a suit to enjoin future conduct. Most of the issues of constitutional law presented in 1983 damages actions and Bivens also arises in cases where the defense is not available, such as in criminal cases in 1983 cases against municipality, as well as 1983 cases against individuals where injunctive relief is sought instead of or in addition to damages. Let me look up the case it's citing. In a footnote. Oh, that's good news. All right. Any action under 1983, the first step is to identify the contours, district grant judgment. We have held the better approach to resolving cases is determine whether a plaintiff has alleged deprivation of constitutional rights. Clearly established. I don't know what the Supreme Court's trying to say here. An immunity determination without more provides no clear standard, constitutional or non-constitutional. In practical terms, escape from uncertainty would require the issue to arise in a suit to enjoin future conduct. In none of these instances will qualified be immunity available to block determination of the law. Okay, so I think what this is saying, as I speed read and speed analyze two different U.S. Supreme Court cases to try to understand what they're saying. I think they're saying, and don't hold me to this, but I think they're saying that qualified immunity isn't available in the injunctive cause of action. I don't think, despite its wording, that it's trying to say for all causes of action if an injunctive relief is given. Yeah. 1983 cases against an individual where injunctive relief is sought instead of or in addition to damages. And then they have a footnote citation. I think, and then you go read the footnote. I think they're saying it only is for the injunctive cause of action, but don't hold me to that. So, and the district court could cite that obviously as a basis, and I'm not sure that that's the right reading of it. But, maybe in a future Court of Appeals case, we'll have a decision on what exactly the Supreme Court was trying to say there. But yeah, a qualified immunity is not relevant to the injunctive cause of action. But particularly because the injunctive cause of action is about to disappear, I don't know what happens next. As I speed read two different U.S. Supreme Court cases, but I'm not sure. Which two cases? It was Pearson versus Callahan, 555 U.S. 223, and it was County of Sacramento versus Lewis, 523 U.S. 833 at footnote 5. Yeah, it was the two cases I was trying to figure out, but I think that's what they're saying, so yeah. Oh yeah, old cases are fine. We don't care about cramp. Old cases are great. We've covered old cases. As long as they're published, man. This makes it fine, but yeah. So yeah, let's try the. I'm not. I think the Supreme Court was only talking about qualified immunity. Only talking about the injunctive cause of action. I don't think they were speaking universally. And since the injunctive cause of action is about to disappear, I don't know what that means for qualified immunity. If I'm speed reading it correctly, it wouldn't influence the analysis, but who knows? Did the defense bring up qualified immunity? As memory serves. Otherwise, this entire discussion is kind of pointless. If they didn't bring qualified immunity at all, I'm going to look like a real idiot. You're just trying to make me look bad, aren't you? Yes, they brought it up. It's in the affirmative defenses on page 13 of the answer. So, yeah. I'm going to end the stream now before you guys ask me more questions. I don't have a locals page yet. Maybe I should get one. I don't know. If you've enjoyed this stream, including where I try to analyze what the Supreme Court was really trying to say, please remember to give it a like. If you're not subscribed already, please subscribe. And you know, for 99 cents, you too can torture me by asking me questions that I'll be compelled to look up because, I'm a legal analysis channel and I can't resist the temptation. It's true. So do all those YouTube-y things. I'm going to leave now and go back to my day job. I hope all is well. Cheers and goodbye.